Good morning. Welcome everyone to the Committee on Professional Responsibility and Conduct. I will remind everyone that this meeting is being recorded. Angela, would you be so kind as to take the roll?
Sure. Sarah Bonola, Elizabeth Bradley, Raquel Brigham-Brown,
Present.
Cassidy Chivers,
Here.
Mary Grace Guzman, Brandon Krieger.
Here. And Mary Grace is here, but she was muted.
Okay,
Yeah,
Mary Grace.
sorry about that.
Thank you. Joel Mark,
Here.
Eleanor Mercado,
Here.
William Munoz, Daniel O'Reilly,
Here.
Bakita Poindexter,
Here.
and Topeka Robbie.
Here.
Thank you.
Great. Thank you. So next on the agenda is the call for public comment.
Okay, for those participating by Zoom, please use the raise hand function at this time if you'd like to make a public comment. If you're using your telephone, you can press *9, and we will allow 3 minutes for each speaker. The on-screen timer will begin as soon as you start your comment, and you'll have a 30-second warning. Is there anybody right now who'd like to give a public comment? Please use the raise hand function. No public comments.
All right. Well, then we're going to move to approval of the minutes from the last meeting. Does anyone have any corrections or modifications to the minutes to bring up? Then may I have a motion and a second?
So move.
Second.
Fantastic.
Sorry, who was the second?
Eleanor.
Eleanor, thank you. All right, I'll take the vote now. Brown,
Yes.
Bradley, Chivers,
Yes.
Guzman,
Yes. Need to find the button.
Mark,
Yes.
Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter,
Yeah. Excuse me. Yes.
Robbie,
Yes.
and Krieger.
Yes. Great.
All right, 9 yeses, so the motion carries.
Okay. Before we start going down the agenda, Erica and Angela, since we have a couple matters that will require a full committee vote, is this order still okay or optimal, or should we reshuffle anything?
I think it kind of depends on the group. So we were notified that 2 people will have to leave either for a little bit or for the entirety of the afternoon. There are 3 items that don't need to be, but ideally will be voted out today. And that includes the conversion clause opinion 20-0005, ideally for a second public comment period. And then also Arbitration Advisory 2022-0XA, which has returned from public comment and has some minor modifications. And then the third item would be the consideration of ABA model rule changes to Rule 1.16 and voting on whether or not to make any changes or to leave California's version of 1.16 as is. So those are the 3 items that actually need to be voted on. I believe the rest are just kind of general discussion and next steps for a future meeting. So depending, we could certainly go out of order and take those 3 to kind of relieve the members of any concerns about not having a quorum for those votes. That may be prudent to do.
Yeah.
But we do certainly have a quorum now.
I was just going to suggest, unless there's any objection, why don't we start with the conversion clause? Because that was the razor's edge straw poll last time. So we want as many people here to participate as possible. And the goal there, Joel has circulated a draft consistent with the very slight majority view in the last go round. Goal would be to vote that out for public comment. And again, it's not a final approval of the opinion. It is gather more voices, insights, and bring it back to the table and see what we all think. But unless anyone disagrees, I would propose we start with that and let Joel sort of walk us through the clean draft that he has prepared. Oh, Joel, you're muted or something. Okay,
Okay, the clean draft actually was before the committee at the last meeting. And I took another look at it and made a couple of corrections which were reflected in the red lines. And then thanks to Deepika, who took a more thorough look at it, she circulated it back to Brandon and I. And we have made it more clear that the intention of the opinion is consistent with the straw poll, albeit the slight majority, as Brandon emphasizes, was to send it out as a no exceptions, no hypothetical piece. And I'm satisfied. Oh, also, I recall that I did ask for any further comments from the group at the last meeting. And so that opportunity was afforded. And what we have then, I think, is a good, clean draft, which I would propose be voted out for public comment. And so we can see if our straw vote carries the day or if it doesn't. I think after 4+ years, it's time to do that. And so I will just leave it open now to anybody who has any questions about the red line.
well, this is gonna go pretty quickly, one way or the other. Yeah, my 2 cents on this is, you know, we obviously have a diversity of opinions in the committee on the ultimate merit of this draft, but as some of us have done with other slightly disputed issues, voting something out for public comment really does invite really smart voices and informs our further work on the opinion. I think this is in good shape and consistent with what we have talked about, even if it's not everybody's preferred opinion. I think it's in a good spot to circulate and get, input from the public for us to consider. So I think we should vote this out.
I will say that I think it went out for public comment almost 2 years ago. And I have a feeling most people are going to forget that they had seen it before. So we're probably going to get a lot of the same comments back, but
Yes,
that's okay. I think those will be helpful and see if any perspectives have changed. And I really think it's time to do this. So I'm with you, Brandon.
does anyone? Oh, yeah, sorry. Let's start with Raquel.
Hi, thanks.
And I'm going to apologize. I'm very bad at looking for the little hand signs. I'll do my best, and I'm not trying to be rude to anyone. Okay.
Joel, how different is this current version from what went out as an opinion before?
Substantively, it is not much
Okay.
different at all. Stylistically, it's a lot different and a lot better thanks to Deepika's work. So, but it just holds to the proposition that it's our belief that a conversion clause in the limited circumstance, separate from what we might call a hybrid contract or fee agreement, which we call out in the footnote as being accepted from this. I think it's in very good shape and it's consistent with the prior draft in terms of its substance.
So, Joel, if I can just jump in for a second. Raquel, I'm not certain if your question meant the one from the last meeting. Joel's comments are absolutely right, that it's stylistic changes, that Deepika had some great, drafting input. But if you're talking about the one that went out for public comment like a year plus ago, the difference is.
Yeah, that was the question, is
Okay.
the public comment.
Right,
Sorry.
so that one had all the same thrusts and arguments in it, but it left the door open a little crack. It said, these things are unlikely to be okay. it might be possible they're okay, but we don't see it, you know, and this one just shuts the door completely. It just takes a stand that this is not permissible. Eleanor?
Is this definition of a conversion clause in the digest new, or was that in the opinion before?
That was in the opinion before. I don't believe it was in the digest. Is that right? I think that's right. Because it's like one of the first sentences of the opinion itself too.
Okay.
And that was one of the public comments that we define it up front.
And so if I'm reading it correctly, we're not interpreting it to apply to anything outside of the context of litigation. Is that correct?
No, that's not correct, because contingent fee agreements can apply. The notable case is the oh gosh, what's the name of it? Allnote case, which was a contingent fee based upon a reduction in the tax liability.
Right, right.
And so it would apply to any case where there's a contingent fee agreement, which is subject to 6147 of the B&P code.
I guess
Erica, are you-
what was jumping out at me was the refusal to settle on terms recommended,
Yeah.
and wondering if other contingencies or other events could potentially have the same effect in the context of a transaction.
Well, it's not limited to just that contingency. I mean, just that one instance.
Right. It may, and maybe we want to say, you know, well, as I read the digest, it sounds like it's limited. It's termination or refusal to settle.
Right, which is
Maybe we want to adjust that a little.
the only ones that I recall in however many 40 some years of doing these things that this is, I mean, I've ever seen that kind of contingent.
Yeah, that's what I always see, but you're raising an interesting question, Eleanor. Are you able to flesh out what a triggering conversion event might be in a non-litigation context other than this? Just because I haven't thought of it that way.
I need to give it a little bit more thought to see if this would apply. What's coming to mind, and I haven't fully fleshed it out, is a transaction where you might have a fee set on a percentage, say,
Right.
underwriter, you know, fee or something like that. And then the transaction busts and it converts to something else, but it busts because they decide not to settle or not to go forward.
Right.
Something like that. So and I need to give it a little more thought, but I'm sure there are examples that we might want to capture.
Yeah, I've actually seen that, and that's what I was thinking too. If just a deal doesn't go through and the agreement is a percentage of the deal, you know, whatever that is. But for whatever reason, there's no meeting, you know, there's no you know, consummation of the deal between the two parties, and it would revert to an hourly fee. And I've seen that in fee agreements, and I think that I don't think this should cover that scenario. I think that
agree.
attorneys and clients should be free to adapt, you know, those two alternatives, basically.
That's interesting. In a non-litigation context.
Yeah. Yeah, because it's you know, it's not like it's not like a refusal to settle situation. That's not covered.
Right.
Doesn't fall under that. And it's not, you know, the lawyer isn't, there's no termination of their representation either.
Right.
You know, it's basically the, you know, freedom of contract between attorney and client on how they want the representation to work.
But
And we're sliding back into our objections to it overall. But
Right, right,
I
right.
think the transactional thing is it's a good way of kind of teasing out some of the concerns.
I'm not so sure I agree with that, because if the fee is based upon the happening of a contingent event, and it doesn't happen, whether that arises in a business context, a tax context, or a litigation context, the basis of the fee is the attorney's agreement to take the risk and base their fee on a higher fee on the fact that there is a risk. And
Not necessarily, though. I
No,
mean,
that's
that's
yeah.
one factor in allowing for contingency fees. But I think that if, if the hourly rate is not unconscionable, and it's spelled out properly, then I think, it doesn't violate. I don't think it violates the rules that we're talking about in here.
I agree. It doesn't interfere with your right to choose counsel or discharge counsel. I don't think the policy issues are implicated at all. And it's a very common structure.
And maybe one of the reasons Joel and I, in all of our fee dispute life, have not seen it is because it doesn't generate disputes and it isn't used abusively.
Right.
Elizabeth has had her hand raised for a while.
But under the examples that you guys just gave, it seems to me like your examples would not be covered by this opinion, because you just said in that situation, there's not a termination of the relationship or a refusal to settle on terms recommended by the attorney. So wouldn't your examples fall outside of the scope of this opinion, and the opinion would not be applicable?
I thought
Well,
we
that's
started on the premise that this was not exclusive, the refusal to settle. It was just a non-happening of the contingency. That's why I was querying that
Right.
at the outset.
I think it's
Right.
unclear. I think it might be necessary to clarify it, because, we're raising that question. So if we're not sure about it, then, the reader might not be sure about it either.
On the termination of the relationship or refusal to settle on terms recommended. Because that's all we're defining a conversion clause to be
Right.
a change in the compensation triggered by termination of the relationship or refusal to settle on recommended grounds. I don't think the scenario you're talking about fits in that definition. I wonder is this something that could be could we construct a footnote in the opinion to make that clear if that is the opinion of the committee?
I'd like to hear from Joel, because I don't think that was his that wasn't
Right.
understood to be his
Right.
description of the purpose.
Yeah, because what I would suggest, what I would prefer is that it's limited to the litigation context, but that's not Joel's understanding. So,
Right.
I think it would also be helpful to have it a defined term with capitals, conversion clause, and that might help the ambiguity, showing that it is the defined term as used in this opinion. And use those capital C every time in the opinion that you're using it.
Mhm. So that's a great idea that I can't imagine anyone's going to object to the defined term, but the substantive issue here is, is it the sense of our committee that this applies only to litigation, or does it apply outside of that? So Dan, you've had your hand raised.
Yeah, I was just going to say that, to me, the analogous situation in a non-litigation context would be where the agreement says, if the deal doesn't go through because of something that you do unreasonably, then I'm going to get this hourly rate or something along those lines. But I wouldn't necessarily limit it just to litigation.
well, if somebody is going to propose a footnote or a limitation, then I'd like to see them distinguish it from the Allnor case, which is a non-litigation situation. And there's a very lengthy discussion about a contingent fee is exactly that. If it doesn't happen, you don't get paid.
Well, I'm talking about something that's outside the contingency, just like a refusal to settle, right? If you are being unreasonable, that's not that the contingency didn't happen. It's because it didn't happen because of you, just like a refusal to settle.
Well,
But Dan, your point is that the same logic then of this opinion would make that an improper conversion clause.
It would appear to apply.
Yeah.
And
You know,
I
Or should
really,
be distinguished.
Because, I mean, one of the contingencies that you undertake, in any case, is that your client's a liar.
yeah,
Well, you also undertake a contingency that they won't settle, right?
right, right. But we got a huge amount of pushback on that, you know, and I don't agree with the pushback, but the public comments, there were so many lawyers saying, you know, we can't be at the mercy of bad faith clients. We can't waste our time. But, you know, I have always believed the contingent fee premium accounts for all sorts of risks, including that risk. You
Right.
know. Raquel?
So,
Hold on a second, Joel. Raquel had her hand raised.
sorry,
I think, Dan, can you say what you were saying? I'm gonna make a point, but I realize what you said, I didn't completely understand, and it may meet what I was thinking or go against it, which is, I felt like the difference between the cases that Eleanor and Cassidy were talking about is there's no dispute in the change in fee. Right, so the client and the attorney are agreeing, and so to me, it does fall outside of this opinion. Because the issue in this opinion is around a dispute between the two parties.
I don't
And
know
so-
if that's true, actually, Raquel. I don't think so.
Okay, that's
But,
what I
but
heard.
I'm kind of with you there, and that, like, I think you're onto something in terms of why we're raising concerns about this. But
So
Yeah,
that's what I
and-
I
hear
don't think
you
that's
guys
enough.
talking about. To me, is that if I'm the client and one of you are my attorneys, and we have prearranged the terms of our relationship of this deal, whatever the deal is, whether it's litigation or some other matter. And in this case, you all are talking about things that are not litigation, but because of the nature of whatever the situation is, the deal does not happen. And so then this contingency converts to what we have already forethought in our contract, that if this doesn't happen, then this will happen in terms of the fee. And as long as we agree with that as client and attorney, then to me, the spirit of why we have this conversion opinion does not relate. It's because it's the spirit. The spirit of this is to settle these things on either side when either party feels that now around the money, the circumstances have changed in a way that's unfavorable to either side. And what you all are talking about is something that changes, but it's seemed to not be disfavorable to either side.
So
Yeah,
another way,
Maybe on a technical, but I think what we're talking about is what is the spirit of why we have the opinion? And the spirit is
It's
Yeah.
the
there's a disagreement.
It's the coercion nature of
Right.
what's going on here. And under the deal scenario, there is no
right.
coercion. And another, and I
No.
don't know. Okay, well,
Another way to look at it is that the two rules of professional conduct that we are saying that we are protecting with this opinion have to do with the unfettered right to change counsel and have to do with the right to determine your own litigation outcomes as a client, right? And
Yeah.
Or transactional outcomes.
yeah.
yeah, but
What's
there's, yeah.
what's giving me pause is neither of those rights sound to me to be implicated, burdened, or violated by, you know, what Cassidy and Eleanor are talking about here. There is no it has nothing to do with the right to change counsel. It has nothing to do with invading the client's right to determine litigation outcome or transaction outcomes. It's an external factor made a deal not happen.
Well, no, but in my example,
No,
it's
no,
not an external
Brandon,
factor.
Brandon.
It's
Hold on, Joel. Hold on,
expressing-
Joel. What's that, Dan?
Just quickly, in my example, it's not an external factor. It's not that the deal didn't happen because the universe didn't want it. It's because the client woke up and said, I don't feel like doing the deal.
Yeah.
And the lawyer has, spent months and time and money getting ready for it, this contingency. That's the payoff. And to me, that's analogous to the refusal to settle. They do have the decision whether to settle or not and when. The client in the transaction can walk away at any time.
Yeah.
But
It's
you're
kind of the
assuming that
thing.
the economics support that, which they don't necessarily. The economics may be that there's some minor increase in the fee if it goes through, or that it's a normal fee if it goes through, just normal kind of standard type of fee. And that it's heavily discounted if it doesn't, just as a commercial matter.
Is
Right?
that
And that's
coercive,
very
though?
often the case.
How,
Isn't that coercive of the choice? It seems analogous to me.
I don't think
So
so.
it-
I mean, I think the lawyer's the one taking the hit if it doesn't go through usually by discounting the fee significantly, but that's the conversion.
Yeah, I mean, I think,
Beneficial to the client.
how would you feel if the contingent fee for a litigation case said that if the jury comes back with 0, I still get my hourly rate? That's no different from when you're in a negotiation on a business deal and the other side walks away. That's the risk you take. And that's why you justify your higher fee, which is going to be more usually than your expected hourly rate, because you're taking a percentage of the deal and you're drawing in your client, you're advertising your services, no recovery, you don't pay.
Well,
I
but
think
that's
there's
not the
an-
case with
there's- I-
transactional lawyers. That's not the case with transactional lawyers.
No,
They
and
get to
I think there's
their
a-
stuff in all sorts of different ways.
there's enough, there's definitely similarities in the two scenarios, but there's enough difference that makes it fundamentally different for purposes of this rule or this opinion. I mean, I would think that if like for example, and I don't know where it exactly fits in here, but if you are going to take an interest in the deal, whatever the revenue from the deal, you have to comply with rule 1.8.1, right? But with a contingency fee
You
agreement, you don't. And so, why is that? Why is there a difference there? I don't know, but I think that deal transactional matters, a contingency type agreement under a deal transactional matter is different than litigation.
Cassidy, if I may, on your point, the fact that in a transactional matter, you have to comply with 1.8.1 ensures that the terms to the client are fair and reasonable.
Right.
In a way that Joel and I have been talking for 4 years. There's no such protection for a litigation client, because that was what we were kind of focusing on. I am struck by this distinction. I think it's pretty interesting, because the entire world, I've seen so much abuse on these conversion clauses, and it's always in just what Joel said. The advertisement, you can't afford litigation, we got you. You don't pay unless you collect. Don't worry. All that is just baked into litigation contingencies, as are the risk premiums. Sophisticated businesses doing capital raises or deals are not the same.
Right.
I
And
see
the
distinction.
hourly conversion, and to Eleanor, I think Eleanor's point is that that can be judged from an unconscionability standard. It still could be an improper fee, but if it's doesn't take into account the the situation,
But you're not even
but
going to have to get to unconscionability, because if you have to comply with 1.8.1,
oh, right.
you're stuck at
right.
reasonableness, which is not a
Well-
protection available to an injured client plaintiff.
Well, they can be
Yeah.
structured differently. I mean, it won't necessarily implicate like taking a portion of the transaction. Like there's all kinds of different possible structures. So that won't always be it. But
I mean, my thinking is that if we're talking about what is the definition of a conversion clause, in my mind, it's start with Joel's point that everything that's contingent is part of the deal where you get the risk premium. But a conversion clause is starting to exclude things from that and treating them differently. And I think it should be as broad as that. If you take anything out of the contingency for which you got the risk premium and say, but we're going to do this differently if this happens, or if you decide to do this or that or the other thing. I don't think it would be limited to two scenarios.
There's an assumption there that there's, I mean, I disagree, but I will also point out that there's an assumption there that there's a risk premium. And there isn't always a risk premium. Sometimes there's just a discount.
Well, I will also note that we are,
Well, then, Eleanor, to your point, that's why you don't believe there should be a blanket rule, because there would be no reason for banning conversion clauses if there were a discount, right?
But we are
Exactly. I
fine.
mean,
We are
there's many
fine.
reasons, but yes.
But we are fine with hybrid agreements. Half of a, a typical contingent fee, half of a typical hourly fee. We're fine with that. And that's a massive hedge. And in some senses, that's a little bit similar to what,
Right.
not what this opinion was aimed at, but what Cassidy and Eleanor are talking about.
Yeah, except
that's
that's
what I would-
decided up front, right? It's not dependent on what they do after the fact.
Yeah.
Well,
I don't know. I think it's at least, I mean, if you want this opinion to cover our scenarios, the transactional scenarios, then that's definitely not clear. Refusal to settle is not the same as walking away from a deal, in my mind. So,
agree.
and I don't want it to cover that I just think it's too different, and that's my position on that. So I don't want it to cover transactional matters. I think it's too fraught. But if you do intend it, I think it needs to be clarified.
If I had a client that was wronged by a lawyer client that was wronged by a client that pulled out in bad faith at the last minute or whatever, I would cite this opinion in a transactional context and say, look, they banned conversion clauses. This is the conversion clause. Same thing.
But then I would be on the other side saying, no, that doesn't apply.
Send it for public comment.
Erica?
So to some extent, I think this has been a really good discussion, but I also think that we're back to where we were a month ago. Because what you're describing essentially is there used to be that, I believe it was the third scenario, which was it works in these are banned in every single context except for this very specific context. And the public comment was, you'll never get that scenario. And I think the working group spent a lot of time trying to find a scenario for which a conversion clause would be applicable. And I'm not sure this was described as that. So to me, the committee seems like there's two divergent paths to take to make a very clear definition for which transactional matters would not be contained within, either by clarifying the definition that's in the digest or adding a footnote to exclude certain things, or going back to where you were a few months ago and saying conversion clauses are always banned except for in very fair scenarios, which would be a different revised version of what used to be that scenario that was since removed.
Right. Eleanor?
I think what is being highlighted by this, and I freely acknowledge I have a different view than the majority took, in our last straw poll, but I think what's being highlighted by this is that it's different for sophisticated clients because the same policy implications are not present. And I really think we should be focusing on the principles and the rules as opposed to making a per se rule. I don't see it in the case law. And, so I will just make my plug for that again. I think the issue here is whether or not it's actually impinging on their right to choose counsel or direct the outcome. And that's where the opinion should be focused.
You believe like the draft from a year and a half ago, which was here are all the ways in which it can be unethical and all the reasons it could be unethical, but you have to look at each instance.
And it will often be unethical if the result is that it's going to interfere with their right to choose counsel or change counsel or direct the outcome of the case. And, I'm very comfortable with a strong opinion that says in many, many cases, this is unethical.
So the rationale for sending it for public opinion was to get that feedback. So because the straw poll was so close, I'm still in favor of doing that. There might be other scenarios we haven't thought of that the public comment reveals. And this is testing for the first time the per se rule. It's never been out there before.
I do think,
a lot of comments.
and this is interesting because I vote differently on public comment, putting something out for public comment than I do on a final opinion. I really do that because I always think, you know, we get better, not all our input. Obviously, anyone who's read our public comments knows that there are many of them that are absurd, but we do get some really smart, critical thought that improves our work. And so I still would vote this out for public comment. And I would like to do that. I'm very respectful of the positions Cassidy and Elnor have brought up. And if this were a vote for a final opinion, I probably wouldn't vote it out so cavalierly. We'd keep digging. But I think it's time for some more input to come in. And so for that reason, I would suggest we vote it out for public comment.
Just as a point of order, Joel's about to run and jump in that lake behind him. there.
I know. I just need Joel to be able to say yes on his vote and then hit mute again without saying anything too, I'm with you, Joel. Joel and I have, this has been a long, ridiculous road on this opinion. And we're not near the end. We're just trying to get it out for public comment.
Well, what I mean, no, I'm not going to jump in the lake, although I'm now bearing the frustration of my retired colleague Ken Bacon as well. But we, over the course of this drafting, we kept asking, give us the scenarios. And every time we got a scenario, we would go through it and we would, okay, what are the rules? What are the objectives? What are the protections? What are the back and forth? What's fair? What's reasonable? All that sort of stuff. And each time we did it, we came to the conclusion that it would be improper to do it because you were going to be impinging upon these rights, or just flat out, you were hedging your contingent risk for any outside event. Your client drops dead, I don't know. And that is something that goes back to unconscionability generally, because if you are quoting a rate which is contingent upon the outcome, you are the one who is taking the risks of those unforeseen events that just happen. The jury comes back against you, your client drops dead, your witnesses can't be found, those kinds of things. And so every time we look through one of these scenarios, we came to, no, we've got to come out with a clean opinion like we now have. So again, if we're not going to send this out, then for gosh sakes, give me the scenario.
Well, I
Okay.
think
We'll try.
That's fair.
it's
You know, Joel,
taken a
that's
long time. It's
totally
taken a long
fair.
time, but I
Frustration.
think today was the day that I heard a scenario that I would want to dig much further in. So for that reason, yeah, it would have been lovely if we all thought of this in 2020, but I'm hearing it right
I
now.
wasn't here in 2020.
Right. So it's a totally, but I'm
But
saying,
it's
doing
fair,
it and
Joel.
do-
Yeah, I
Yeah.
know. And this had been kind of rattling around in my brain the last couple of times, but it just didn't gel. So I do apologize for not.
There's no apology necessary. This is not an easy process. This
Yeah.
is not an easy process. And the same way we allow contingent attorneys to hedge their bet with a hybrid agreement, the risk premium has been hedged down, the floor has raised. I'm hearing things that are resonating with me. Joel?
Maybe, well, I can't say that I didn't think of this new scenario before, because throughout this process, I've been informed by the Allnor case, where there's a great discussion about how a transactional contingency has all the same aspects of a litigation contingency. And I would like to see somebody distinguish that case before I would agree that this new scenario is any different from what we've already considered.
All I'm positing, Joel, is that let's get this out for public comment. And this is going to be dealt with before there's a final opinion. And because I agree with you, I'm going to go read Alnor. I'm going to think about everything Cassidy and Eleanor have said. But I would rather not sit on this opinion for another couple months while we do so. I'd rather get this out and then get more feedback that will inform all of this. There will be transactional attorneys, if they pay any attention to this stuff, who are going to, be really upset and do a lot of important thinking on this, then share it with us. I mean, that's my suggestion. Raquel.
Question in a request, I guess. Is it in sending the opinion out, is there a way to ask for feedback specifically? For example, this transactional nuance. So
I'm not aware of
and-
us ever doing that. In fact, usually when we send things out for public comment, other ethics committees that disagree with us lose the nuance that this is just for public comment and they think we've made our minds in stone, and we get a lot of pushback. So I don't
Okay,
know of a
so
mechanism for saying, hey, we invite your comments on this, to sort of like hedge it. I don't know about that.
Okay, so mine is not the hedge. Mine is, as Joel said, if this is a thing and we're going out for public comment, we want to get public comment on this definitely, specifically. So we don't want to find ourselves saying, oh, we think they're going to comment, and then they don't. Like, that's not going to be helpful.
Well, I think it's okay. I
So,
understand your point.
wait,
entirely.
wait. We're Brandon, we're talking over each other. So I think that's also not helpful. I realize. So that's one thing I think we should consider, whether it's not been done before is not, like, that's not my concern. The other thing is, I think the people who find that this transactional thing either falls outside of, or we should do something, I think in the meantime, as Joel suggested, work on something. So let's not wait till the public comment comes back and then start working on it. I think that, at least two people have said some things that, could be persuasive. I think we should be working on it, because I do relate with Joel saying, hey, we thought about all of these things. And so if you have something, work on it. And so I think we can vote it out, but I think the committee needs to keep working behind the scenes on this. And I think we should be specific. It's not going to limit what people say, but it is also when a flag, we need comments around this area. And so those are my comments, and I'm over.
Eleanor?
Yeah, I mean, my comments were similar to Raquel's, and maybe Erica, I see Erica's hand up, so maybe she'll give us some guidance on this, but it was really that I think it would be a shame to put it out without addressing, the issue, and our concerns between transactional and litigation. If we want to put it out more than one time, maybe there's a preamble we can put on it, just to invite the comment, but I'd like to hear what Erica has to say about that. I'm hoping she's going to give us some guidance.
I'll try. So the short answer, yes. So there, as far as public comment, there is a public comment memo that goes out with public comment. And when I raised my hand earlier before this kind of, 30 minutes ago, when we thought, oh, this is just going to go out real quick, no big deal. We can certainly give the procedural history of kind of how this opinion got to where it is. And we can have specific calls in the public comment request. Please consider this issue X, Y, and Z. That said, as Brandon has pointed out, some people read that document and some people don't. And some people give, very helpful, substantive public comment, and some people don't. And it's kind of the luck of the draw to some extent. I do want to point out, though, that based on if this version goes out, it doesn't sound like there may be a quorum to actually adopt it as is in the future, regardless of what public comment says, because of this transactional issue. So you're looking at a round of public comment, modifications to address that, a round of public comment, and then possibly, depending on what comes back again, a third round of public comment going forward on this opinion. And this has already gone out once. There's nothing that precludes that. It just, the state bar rules require that anytime there's substantive modifications to something, it has to go back out for public comment, typically 30 days at a minimum. Sometimes it's less, but obviously the goal of public comment is to actually get comments usually. So, you know, it would probably be 30 days. So it's just really moving this opinion more slowly than I think some would like, especially considering that it's, you know, been around for about 4 years, and people that are invested in this opinion are going to be terming off in that time frame. So that's just procedurally how this all works. I don't know if that changes anyone's mind on anything one way or another, but
Does the public comment memo ever make a specific, draw attention to a specific issue? Do you
yeah,
invite public comment on whether this should be limited to litigation context or applied to transactional context?
absolutely. We did that with 8.3, if you'll recall. So, I mean, 2 versions went out, and
Right.
so that there's kind of no, it's just a matter of whether or not you're going to actually get the input you request. And you would hope so, and obviously bringing attention to it would help, but it doesn't mean it's guaranteed.
There's no other, I mean, our paths available to us are voted out for public comment now and go through all the long rounds that we're talking about, or continue talking about it for a few more meetings and then put it out for public comment. I mean, it's different enough that it's going out for public comment either way, right?
Yes, absolutely. But you know, the work that could be done in between may be relevant. So if there's that transactional scenario that I mean, again, this is kind of going back to where we were, but if there's that transactional scenario that makes sense to a majority of the committee to be included, you may reduce a public comment going in the future, let's just say. So you're still looking
Right.
at least 1 round of public comment. It's just from what I'm hearing, I don't think you're going to have a quorum to adopt this version of the opinion. And so I don't know if you guys want to spend
Well,
the time.
I don't think Joel and I are likely to be voting members by the time this thing is dealt with anyway. I mean, it's kind of, and that just is a fact of how time moves in one direction. I'm not sure it really matters. I think I'm absolutely confident that Eleanor and Cassidy will develop their position really well. And even if public comment is garbage on that, we will have a robust discussion of their point, before this thing would ever get approved. My inclination would still be to put it out for public comment. Because I feel like I think it'll breathe some life into it, to be honest. Positive and negative. Eleanor?
Yeah, do you think there's a basis for the distinction between transactional, like just for a clear kind of black line, distinction between the two? Or do you think that it's really driven by sophistication? I guess that's the question I would pose, because if you look at it and you think, well, I hear it, and now I'm sort of, open to this notion that in some circumstances with sophisticated clients, these policies aren't implicated, then I kind of think we ought to explore that. If you're thinking, look, the rules give me a basis to distinguish, then it's probably worth getting comment on that.
Just
That's my
to fill you in, the Eleanor case was $130 million tax liability. And they were arguing over a 3% contingent fee based on the reduction. And the court went to great lengths to say that these are really sophisticated people, and they spent time negotiating the deal. But it's the public policy behind the rule which trumps all that. And in that case, it was the fact that they didn't have the magic language that said, this contract is subject to negotiation. So without it, they said, sorry, you don't get it, because of the public policy behind the rules which are applicable to contingent fee contracts among the most sophisticated parties. So if we
Can I ask sorry, Joel, I don't mean to interrupt. What was the transaction in that case?
$130 million tax liability, I think.
What do you mean? Like there was, sorry, I don't mean to not understand, but I don't understand what was the deal? What was the contract that was at issue?
No, it was a proposed tax liability, which the attorney was hired to reduce.
To
And,
negotiate with the IRS? I mean, that's,
let's see. Liker is an attorney who specializes in tax matters and complex business transactions. Liker entered into a services agreement with petitioners on all. The agreement obliges Liker to provide advisory services aimed at minimizing the adverse economic impact arising from a specified taxable income. Under the fee agreement, Liker was supposed to receive a $20,000 per month stipend and a success fee of 2%, which was later modified to 3%.
that sounds more like a hybrid agreement, but it also doesn't, it's not tied to any sort of transaction where there's two sides to a deal. It's more about, you know, a tax liability or a tax consequence. So it is, you know, like a, you know, what the IRS is going to impose, right?
What authority is there that says that when you take a case on a contingency basis, if the other, and it's a transactional deal and the other side drops out, that's different?
I mean, it is just different because there's all kinds of different
authority.
variables to a deal. I mean, I don't have authority, but I don't think your case is the authority. Is what I think that there are distinguishing points between, you know, your case and just your, you know, typical deal transaction where there's arm's length negotiations, and those negotiations, you know, take into account all kinds of, you know, unforeseen events that are not.
What happened in Elnor, Joel, that triggered the dispute about a fee?
Yeah.
The
Sorry.
contract.
Now we're on appellate court.
No, the contract simply didn't comply with 6147 because of the absence of the magic sentence.
That it was negotiable by law?
Yeah. And the
And
court
so the
said,
client just
"Sorry,
refused to pay.
you
the
don't
client
get
just
to enforce
refused-
it."
Yeah. So then it's a quantum merit dispute?
Yeah.
Okay. I view that as, it's an adversarial type proceeding, much more akin to a litigation. I think. I mean, I need to read the case. I was gonna,
Yeah. Do you
my
have
hope
the
was that we
site?
wrote this out for public comment and then I read the case and let Cassidy and Eleanor beat me up and see where we go. Cause I'm trying to be very open-minded. And I feel like this opinion is just stuck in mud. It's, and I think it's an important enough issue, 100% with respect to every time I've ever seen it has been in the litigation context, and it's been so abusive and terrible. I want to move this thing forward and get some outside stimulus to juice up my successors, because I'll be long gone when this thing goes out.
I'd like to make a motion to send it out for public comment with a public comment memo.
And the public
Yeah, I agree
comment
with
memo
that.
will draw specific attention to a litigation versus transactional context question.
Right.
I
Second.
second that. Or we all, many of us. Oh, Raquel, do you have a comment?
I want to add on to that, just to be specific, we are looking for comments for the application, implications, distinctions, or considerations to transactional matters. So I wanted to just make it broad enough that people can say what they want, but that they know
Yes.
this is kind of what we want. And so it's not meant to limit.
Right.
It's just meant to encourage. So since Dan's making the motion that included the memo, I wanted to add some language.
So amended.
Eleanor?
I'd be interested in taking a look at the language in the memo just to make sure it kind of, I mean, I would like to hear what the public has to say about whether or not there's a basis for the distinction between the two. If it's really based on whether the policies are implicated, as opposed to a clear distinction between transactional and litigation, which is my position.
Well, what if the public memo asks both of those?
That's
phrases
if
it both
it-
ways, right?
If it gets to both of those and says that, you know, acknowledges that the committee is fairly split on this,
Mhm.
I would support it.
And
going.
seeking input.
Yeah, fair.
Yeah, just to be honest, I think that any transactional lawyer reading this opinion would go, well, this doesn't apply to me,
I
without
agree.
some sort of
Well, you should send it to some of your transactional friends.
I will.
Once we send this out, and they will write great comments to us. Erica, is it acceptable? Do we need to be more specific now in our vote as to what's in the memo, or can we vote this out for public comment with the memo to generally hit these things and we work out the language later in the memo?
So traditionally, for whatever that's worth, staff just writes a public comment memo that goes out for public comment. It's not usually something that where COPRAC provides input. It's just we are seeking public, the committee seeks public comment on X, Y, and Z. I've been taking notes.
Okay, are
So
you comfortable?
if
You comfortable you captured the
not, I can
various-
reach out to a few of you to not
Yes.
have a quorum, but I understand the general intent.
Yeah.
The reason I raised my hand is because I want to know how long you want to issue this for public comment for. And I'm assuming 60 at minimum.
That's what I would have thought as well. Joel?
Minimum.
Just to kind of give you something to think about. Paragraph 5.82 of the Rudder Guide says contingent fees are not limited to litigation matters. They be utilized in business transactions citing or now. The lawyer's fee may be contingent upon the successful conclusion of a transaction, services in connection with public stock offerings and mergers and acquisitions. Can charge a percentage of the funds raised contingent upon the completion of the transaction and tax matters, citing the Arnall case. So the Rudder Group doesn't draw distinctions between looking at a contingent fee based upon that it's not a litigation matter. So
What was that site again, Joel? Not 5 point what?
5:82, I think it was. Wait, let me get it again for you.
Sorry. Oh, I got it. Yeah.
Yeah, 581, 582 to 584.
So we have a motion pending with some friendly amendments. Oh, Topeka, you have a hand raised now.
Just to follow up on Erica's question, what are our options for public comment periods? Is 60 the shortest period or the standard?
So 30 is typically the shortest. So this committee is very unique, just for context. So typically the board is the only entity at the state bar that can issue something for public comment, except for COPRAC. COPRAC has retained authority to issue things independently for public comment. We do try and adhere to the state bar rules for issuing things for public comment, and those say, typically no less than 30 days, but it's typically. So there is some flexibility there. Just generally, the state bar typically issues things for at least 45 to 60 days for public comment. This committee oftentimes errs longer to 90 days, or has been more recently, because we received a lot of input from organizations, bar associations that give public comment that procedurally, because of what they need to do to vote on, their public comment memos, et cetera, they need more time. So this is an item that has already gone out for public comment. That being said, it's a very different opinion than what went out for public, I would say different opinion that went out for public comment last time. So I would recommend 60, otherwise you're going to end up where we were at the last meeting, where we had to extend public comment period on something for the benefit of those associations that wish to give comment.
All right.
So 45 is too short, Erica? In your
Yeah, there's no bright line. I mean, you could certainly issue it for a 45-day public comment period. However, again, that's maybe not enough time for them to give substantive input based on when their committees meet and vote out.
We tend to get a lot of our best comments from these other, county ethics committees or CLA, and they are on really, they're on their own schedule. So they do need some runway on that. And when we don't want to deprive ourselves of that comment. I think that's useful stuff. So I vote for 60.
if we were voting.
Right.
And I'll just, I think that brings this back, assuming that we can get the memo done relatively quickly. That would bring this back for the September meeting, because there's we have a July meeting that's going to be here before we know it, and then there's an August break, bringing it back for September. So September 13th meeting would be that meeting. And everyone that's sitting here today will be at that meeting, or if they can attend, but they are all still on the committee.
Okay. So I think we should return to Dan's motion here with as amended, and we're gonna have a good faith memo really setting out this area of tension and inquiry, and get some good public comments here. Does anyone want to make any amendments to the motion, or are we good to vote on it?
Somebody has to second it, I think.
I second it.
Yeah.
So can I put one additional comment out there, which is to have the memo call out the circumstance where the contingency is actually a discount, and the fee is not necessarily inflated, doesn't build in a premium.
You mean the hourly fee, like the
So
Alternative
sorry, the
fee.
contingency, yeah, the fee is a normal hourly fee, or doesn't build in a premium.
What do you mean by a discount? Because
So when, like,
No,
if a
no.
transaction doesn't go through, you don't get your percentage, which may or may not reflect a premium. And you're oftentimes reverting to a discounted fee.
The alternate fee is a
Heavily
discounted.
discounted, where unconscionability or reasonability would never be an issue.
how do you measure whether it's a premium or not? I mean, you're gonna say, I mean, you can.
Well, it's a fair point, but
No,
there's an
no,
assumption
it's
that
like
there is.
a litigation, you know, there's the standard 33% and all that kind of stuff. But then in
Right.
transactional matters, you look at it in terms of the work involved, the risk involved, and the amount involved. And as in the case of the Arnold case, it was 3% of the tax savings. And there's no way to say if that was a discount or not a discount. It was just what they decided was the fair amount of the compensation if the deal went through. And everybody did that in light of the fact that there was a risk that nothing would be recovered, nothing would be obtained, the deal might not go through. So I'm not sure. You're going to have to define to me what your discount is and why that's significant and how it changes it at all.
Okay, let me say it differently. Suppose there was a negotiated fee for a transaction that was, let's just say it wasn't unconscionable, whatever it is. We don't even need to focus on what that is, whatever it is. So the transaction doesn't go through and a discounted fee kicks in. So, and really what that is clients are negotiating that so that they're not paying full freight for a busted transaction.
But then
And attorneys are saying, okay, if it doesn't go through, you know, we're going to make a fair amount of money if it does. Maybe there's a premium on it, maybe there's not. We don't need to argue about that. If it doesn't go through, you pay what, 20% of what we might otherwise charge you on an hourly or something like that.
Then you run into the Fracassi teaching, which is until the happening of the contingency, you can't calculate the reasonable value of the fee. So
I guess and I'm going to call on Raquel in 1 second here. My thought is I think we came up with 2 areas of inquiry in our memo that we're inviting comment on that are helpful. I don't want to sort of litigate our differences in the memo. And I am, and I mean this with absolute respect, I am certain that Cassidy and Eleanor's position will be represented at the September meeting, at the very least by Cassidy and Eleanor, and we will be digging into this. This is not something to be ignored. That's my 2 cents. Raquel?
I wouldn't want to add a scenario into the memo, because I think then we're trying to guide specific comments. And I don't think we need to do that. I think what we are looking to do is have people use their brain and surface things, which may be what Eleanor said, without being guided there. So the language of whatever we say should be broad enough so that people who deal in transactions will come up with what Eleanor has said, if they think, it's some issue. So that would be my thought, that the language not be scenario based, but be opportunity based for people to think broad and say, how does this play in your world, basically.
Let me just explain where I was going and the reasons. So maybe the committee can help
Okay.
kind of flesh it out a little bit. My concern is that people will not think this applies, which is, I think, how we ended up in this discussion to begin with. I think a lot of transactional lawyers will look at this and say, it doesn't apply to success fees, doesn't apply to discounts, it doesn't, and we may not get the comments we want because of that. That's the concern I'm driving at.
Yeah, that was me too.
So maybe we say something that says why it doesn't apply. It is one of the considerations, like it doesn't, the implications, all the things I said, but also why it does not apply.
Or maybe we add those
And-
types of things to the digest and the definition of the conversion clause so that it just draws people's attention to the fact that this is intended to apply to all of these things. I'm just trying to find a way to make it clear.
Pull in these
Because-
comments.
Yeah, and
Draw them in, yeah.
I won't comment on that because that's a little more technical than me. So I'm not against it based on what I heard you say. It's part of the digest, and that seems fine versus being part of sort of guidance to people to look at it before they start looking at it. Because I do think we do want people in this area to comment. So to me, that's part of why putting it in something. Erica talked about a memo. I'm not thinking a real memo, like something super short, so that people will catch it and say, oh, okay, I want to read this.
Erica?
I think if the goal of public comment for this version of the opinion is to get input that on whether the ban on conversion clauses should apply to every version of a contingency agreement, be it transactional or in litigation or some alternate scenario that we're not considering right now, that should be in the definition of conversion clauses in the opinion. Because then you're not going to have anyone miss it. And if that's not the goal and we just want people to think about whether they think this opinion does apply to them or not, then it could be in the public comment memo. But I really think that if the premise here is that this would apply to every single conversion clause, regardless of the type of matter, that should be in the definition.
I would have no problem putting it in the definition or dropping a footnote or whatever we're doing. I just want it to be, I'm not trying to outflank Eleanor and Cassidy here. I mean, I'm not trying to say that this is our definitive opinion. The goal of that would be to draw the comments from the people for and against. So I would actually ask
I'm in favor of
Cassidy and
that.
Eleanor, you're in favor of it?
Well, I'm in favor of it if it's going out. I wouldn't
Yeah.
send it out, but if it's going out, I think we should just put it in there front and center so we get the comments we need.
And it also
Yeah.
has the benefit of if you don't have to change it later, because after that comment, everyone agrees it should still look like that in that format. You won't have to issue it again for public comment. I don't
On
know
that issue, yeah.
what's going to happen. I'm not sure that's going to happen, but then you would resolve it.
Yeah.
Okay,
Wait,
can I suggest
so-
something then? Can I suggest something? The first sentence of the digest says the conversion clause is a term in a contingency agreement that provides that, etc. Why don't we just say a conversion clause is a term in any contingency agreement, comma, litigation or transactional, comma, that provides.
I think that will get this job done.
I don't know.
No?
See, well, I'm probably in the minority, but I was gonna say I would prefer that it not go in the digest. I would limit it to the opening memo, because as I read it now, it does not include, whereas it can potentially be read to not include transactional. But
Right.
yeah.
Well, I mean, that was what we were trying to avoid, is that we want
know.
people to say, oh, I hate this idea, or I love this idea, just to really front and center it, right?
Yeah, I know. And it's not like I'm voting it to approve it, so I guess it's fine.
Cassidy,
It's
what's your
just-
issue with making it part of the definition? To get people's comments so that people will be specifically, as you all have said, if it doesn't say transactions, people will automatically say it doesn't apply to transactions. So I'm wondering, what is your objection to putting it here so they get the idea that we are saying it does apply to transactions, and so therefore comment if you have an issue with that.
Yeah.
Yeah, I mean, this, that's
Or-
fine. This coupled with the memo, but I guess I don't want it to appear like we're endorsing this definition, this broad definition. But you know, if that is the position of the committee, then I'm not gonna stand in that way. I just don't think that the definition right now should include both litigation and transactional. But again,
Well,
I
But
can vote
Eleanor
against
doesn't
that
think,
when it goes
Eleanor
in.
doesn't think so either, and she wants it in there to draw the comments on it.
Right. No, I know.
You've got
I
your hand
understand that.
raised, So I should not speak.
Yeah,
for you,
I understand
Eleanor.
that.
Or go to footnote 2, where we talk about, this doesn't apply to hybrid agreements. What if we inserted a sentence in front of the first sentence, which says that contingency agreements can arise in litigation and transactional matters. However, this opinion is not intended to address the ethical validity of a hybrid agreement.
Yeah, I mean, I think that's actually, because that's true. I mean, that, that I just looked at the ABA opinion that was cited in the Rudder Guide, which basically says that, although the opinion, and I didn't read it obviously very closely, but the whole opinion then goes on to talk about all the litigation context and does not address transactional at all. It's just a kind of a throwaway comment that, oh, by the way, it also applies to transactional matters. But that seems to be a commonly accepted definition of contingency fee. So I think I would be okay with that approach, but I don't know. I think that you can, I was thinking like you can state that and then cite to the ABA opinion, because that is what it says.
Eleanor?
Can we go back up to the definition in the digest? Thank you. So I think I understood Joel to say that the settlement, the refusal to settlement was not the only type of event, right? So it's not only termination of a relationship or refusal to settlement or refusal to settle on terms recommended by the attorney. I don't think that's clear. So I would just say that if that's what the intent is, we should make that clear, that it's broader than that. These are not exclusive.
I have only focused on those two triggering events in all my contemplation of this opinion. So that's a completely new concept to me, that that a conversion clause could exist and be unethical, not tied to one of these things. I just haven't given that any analysis. I didn't really think that was what this opinion was about.
Okay, well, I mean,
And I guess that's different from how Joel feels about it, so.
it is, so it's a little unclear what we're putting out then, how we see it. And for me, if we adopt your view, Brandon, for transactional, it would just be, the termination of the relationship then, right? Because you can't refuse to settle.
Well, no, I mean, the client could decide after the deal is negotiated, they just want to walk away from it. It wasn't sweet enough.
But that's not clear
That's not
from
what
the
happened.
definition in the digest. That's what I'm saying.
So
If
I think
that's the position we're taking, we should make it clear. And if it's not, then
I think transactional scenarios need to be addressed separately. I mean, I think it's too hard to shoehorn a transactional scenario into this opinion. Anyway,
Well,
sorry.
we could be silent, not have any of these changes in the opinion and count on the policy memo question. We invite public comment on whether the concepts and prohibitions of this opinion apply to all contingent fee representations, including transactions, or should be limited to litigation. We could just put that in the policy memo that 3 people are going to read, I guess, is what I'm
Yeah.
getting.
I really, one, I think the committee needs to confirm, because it doesn't sound like everyone agrees, that the memo, that you're seeking public comment on whether conversion clauses should be banned in every context.
Well,
Just seeking
wait.
public comment on that, because if so, then I think you do want a definition here, again, for purposes of getting public comment, that says a conversion clause is a term in any contingent fee agreement, litigation, or transactional that provides, upon termination of the relationship, refusal to settle on terms, or the decision to walk away from a transactional deal, what have you. And that would be like an including but not limited to examples to address it here and really cover every scenario.
Well, my view is that it should apply in every case. And if we say so, either in the opinion, which I think we should, in one of the 2 ways I suggested, and we get back public comment, which says that we get all the usual suspects from litigation, and we get back some interesting comments on transactional that allows us to be confident that I'm wrong, great. But we're not going to get that unless you say so. Let's say so.
Well, that's what we're talking
And if we
about, right?
don't get back those comments or some kind of authority which says we're wrong, then we can have a different vote when we're informed by that.
So is the highlighted language in the digest sufficient to trigger, it's literally the first thing people are going to read. It's going to, if they read this at all, they will understand that we are saying that this draft applies to everything. We would change the word "a" to any contingent fee agreement, as Erica suggested, and then it's just teed up for the comment.
And the comment should the comment should specifically refer to the highlighted language. I mean, you know what I mean? So it's basically like, please, consider what we've written in the digest and whether or not it applies.
Well,
Yeah.
we'll know, because based on the last round of public comments, we got all sorts of, you could tell who what the practice was of the author of the comment. It was pretty simple, because they gave why it was that this was going to screw their practice. So, and how. So we figured that out. But the only thing I would add is that to the litigation or transactional, just say, conversion clause is a term in a contingency agreement in either a litigation or transactional matter that provides. That's all. And then we'll ask the question.
Yeah, that's fine. I mean, I think, I still think refusal to settle is going to be confusing, but
Yeah, I think you need one more example that relates to transactional matters.
and
So
that's, I mean, then that just, again, it just opens up the opinion more than what it says. Because the refusal to settle is, anyway,
Clearly litigation.
yeah.
right, but I think that's my point, is that the 2 examples you're providing are really litigation examples. There's no transactional example for people to conceptually think about the opinion as far as its applicability to transactional conversion clauses.
Well, there
then
is as to the termination of the attorney-client relationship. If you got most of my deal done and I fire you, and then I still want my percentage. Here, we are not going to perfect this before public comment. I actually we've dialed in on this transactional issue today that was not dialed in on before. We do not agree on it, which is great. We will continue our robust discussion and either agree on it or not. We'll either have an opinion or we won't. But I do think, as modified, and then I would say in any contingent fee agreement, and then the memo will call attention to our request for input on the scope of application to include transactional matters, and we want comment on that. I think this should go out for public comment like that. And obviously, if we make as a committee a decision that it doesn't extend to transactional matters, then there's not much change that would be required here. And if we decide it does include transactional matters, we can go down that road and modify the opinion accordingly.
Yeah,
Eleanor?
And Ellen, Eleanor, for that purpose, I think just saying transactional as opposed to trying to define various types of transactional matters, we're going to maybe even hear of things that we haven't thought about. So any transactional lawyer who sees this and feels that their practice is going to get harmed by it will know.
Well, if they
I don't know if
hopefully.
that's true. I mean, so let me just play devil's advocate for a second, not because I enjoy it, but because I really think there's an issue here. If I'm a transactional attorney reading this, and I don't think that I have the risk of clients terminating the relationship before the deal is consummated, because that's not a common occurrence. Do I think it applies to me? If that's the only risk I'm worried about, okay, I can live with this. I'm not gonna,
Right.
it's evidence to me that it doesn't really apply. It doesn't address the economic realities of what I deal with. There really is minimal risk of a client ever trying to enforce it. And it only would apply in the context of a client firing me. So not going to worry about it.
Well, and then they don't know what refusal to settle means.
Yeah.
They-
And if you
know.
tell me, well, because I don't think it applies to me in the context of a transaction, but if you tell me it's going to apply to success fees, it's going to apply to, a conversion when a deal busts, then I have a totally different reaction to it, because that is the
Well, but-
economic reality of a lot of deals.
I think that can be, I still agree that this should be voted out as is, but that the memo needs to explain, it has to have more explanation that refusal to settle can include a busted deal. So refusal to settle, whether it's because of the client backing out of it or the other side, they're not, meeting the mind, there's no meeting of the minds on deal points, whatever it is. That would fall under refusal to settle, I guess.
Well, it's a refusal to follow the attorney's advice is what we really mean, right? I'm telling you to do this deal. It's the smart deal.
Yeah,
I don't think it is.
I guess, but see, there's so many other ways a deal can fall apart, I mean, that's kind of and I suppose it's true with settlements too, but yeah,
You can't
Erica?
perfect an ownership right. You can think of a million reasons, right?
yeah, because deals are complicated. There's, I mean, and the work that goes into it by the lawyer, so that's why I just think it's so fundamentally different than litigation and a settlement, the client's refusal to settle so that the lawyer gets its, piece of the pie.
Right.
Well,
Eric?
one other option would be just consider limiting this litigation and putting it out there, which addresses, I think, some of the motivation, for wanting it out. It's put it out there as a consideration.
Well, strangely, it actually addresses my entire motivation 600 years ago when I conceived of this opinion was entirely litigation based, because that's all I've ever seen in terms of abuse. I have not, the Eleanor case that Joel is talking about. I need to read it and think about it. But we could have the footnote say this is limited to litigation matters, and then have the memo say we invite comment on whether this should be applied and expanded to transactional as well. I don't know.
Yeah, I mean, I do think we need to have the memo. I do, and I'm okay with including this highlighted language in there with the memo calling attention to it. I think that's fine. And I think, you know, I think Eleanor's right that they may, you know, some transactional lawyers may look at this and go, it doesn't apply to me, but many others will, you know, see the red flag, especially with the memo, and comment. Is there a business law, section of the CLA? Something like that?
Yes, there is. They're primarily who gave comment on the in-house counsel opinion.
Yeah,
Right,
Neil
okay.
Wortley, I believe, is the chair currently, former COPRAC chair.
Of the business law section?
Yeah,
Of
CLA.
Yeah, I mean, can somebody like, you know, that would be a good.
He's at Millbank, right?
He's actually not, he's just retired.
Okay, but he's
Yeah.
got the background of having been at a deal firm, which I think
Yeah.
would be
Yeah.
incredibly useful for comment.
It would be
And
really good.
he also is an expert witness on business transactions, like really high level. So as an expert, he's gonna have thoughts on both ways. I think he's a really great neutral resource, who's not gonna be advocating one way or the other. He's gonna call it how he sees it.
That's great.
And I'm happy to reach out to him and,
Hand him the memo.
yeah.
Yeah, I think that's, I mean, that's a very straightforward way to getting the input we need.
He is
Yeah.
not shy, and I think we'd rather have his public comment privately
Right.
than publicly in a public meeting,
Great,
which he's not shy to do.
great idea.
Thank you,
Dan,
that's a good idea.
Elizabeth.
We are a long way from your motion and second. Are you still comfortable with your motion? Are you,
I think
You
somebody
know-
added a conversion clause to my motion.
right?
What is the current status?
Yeah, I'd like to
It's been
call the
seconded,
question,
hasn't
but
it?
I don't know what the question
Yeah.
is.
It'd be really helpful for staff if it was restated too.
Yeah. A motion to send this as revised out for public comment with a public memo that calls on the public to comment specifically on the applicability of it to transactional matters or other contexts.
Second,
Seconded, yeah.
All right, I'll take the vote. Brown,
yes.
Bradley, Shivers,
Yes.
Guzman, Mary Grace, Mark,
Yes.
Mercado,
No,
Munoz, O'Reilly,
Yes.
Poindexter,
Yes.
Robbie,
Yes.
and Krieger.
Yes.
I was on mute. I was a yes. That's Elizabeth, if you didn't catch me.
Elizabeth, thank you.
Thanks.
So 8 yeses and 1 no, the motion passes.
Well, you guys, that was super easy, and it just tells me that it's gonna be smooth sailing once we get these public comments, and I appreciate all of it.
I think the public comment should end the day after you leave the committee.
Yeah, and then the opinion will just be put in some bookcase somewhere. Listen, that was a robust and really useful discussion, as excruciating as it can be. So I appreciate everyone's input. And we haven't taken a break yet, which is just cruel by me. So how long should we take, Erica, and then come back and run through some stuff before lunch?
Yeah, maybe a 10-minute break.
Perfect.
Yeah.
Thank you.
Thank you, Joel and Brandon, for your work on it.
Thank you very much.
Absolutely. Thank you. And
Thanks.
your patience, your
yeah.
tenacity,
Yeah,
whatever
okay.
it is, all of
Nice
that.
job.
So, 11:42.
All right, hope everyone had a lovely break. And we are gonna we're completely out of order here, trying to get the stuff that we have the highest likelihood of having a quorum for addressed first. So we're gonna move now to item D1. It's the standard of review and fee disputes, whether there is a written agreement. Joel is gonna walk us through his changes after public comments. And you can tell us a little bit about the public comments as well, Joel.
Okay, keep in mind, this is an advisory, arbitration advisory, not an opinion. keep that in mind. And secondly, this makes me wonder why we ask for public comment. If you look at the first comment, it says they want to have their fees lowered because their, bar dues lowered because we're not doing our job. Look at the Girardi situation. The second one says, quote, I want to sue the Judge Judy show for misleading me. I was told I would get paid my lawyer's fees and my car. Okay. I didn't incorporate those. The rest of them, I did. I particularly paid attention to Anahid Ajemian's comments because she served with us on the fee arbitration committee. And I think I put all those in. The other one was from Mr. Brickman, who lives in Arizona. Wrote extensive comments. I tried to get all of those to him. Several others thought it would be helpful. Susan Lee from Oakview commented about how it really was a flat fee comment, which I didn't think was applicable.
Joel, I'm having a little trouble hearing you. Can if you can direct it a little more?
Yeah, okay.
Thank you.
That happens sometimes when I don't hug my computer. And then the long one was the one from the California Lawyers Association Ethics Committee. And I think I've gotten all of those into the draft that I then sent back out, which should be in the materials, you should have received in the materials. So that's about all I can say.
Okay.
We want to go over the red lines. We can
Yeah. Joel, do you want to guide us through any particular substantive changes, or was it all just sort of
No, because they most of them really didn't change the substance of it. They just they clarified a few things, and I didn't make any, if I recall, major changes that were specific comment, but I forgot to print out my red line version myself, so. But yeah, these that you're looking at, that's clarification in accordance with the CLA and Anahid's comments. Let's go to the next one. Same with that. Again, clarifying that we're talking about written contracts that have to comply with the Business and Professions Code. If 6148 doesn't apply, then it can be an oral contract, but it's still an enforceable contract. But that's covered in the fee arbitration advisory about finding a written agreement and what you do with it. This other one was the question was raised in one of the public comments about you're still dealing with making sure that the client wasn't taken advantage of. In other words, they were truly informed. And so we advised the arbitrator to satisfy themselves that the client had given truly informed consent, which I thought was an important addition. Let's keep going. And that was it.
All right. So these are non-substantive changes. They're largely, Erica, there's no reason why we would have to do another round of public anything, right?
Yeah, that's correct. These are non-substantive.
Do the arbitration advisories go to the board as well?
They do.
Lucky
Yes.
board. That's
Because they were
exciting.
subsumed as part of CoPrac's work, they do go to the board for approval.
That's exciting for them. Okay, so let's in my view, unless anyone has any concerns about this advisory, we should vote on it. I thought it was really straightforward all along, really lucid and important and useful for these arbitrators. So I commend Joel on his work. I would move, first off, let me open it up to if anyone has any concerns or comments. All right, I move that we approve this.
I second.
All right, I guess we vote.
Angela, you're on mute.
Sorry about that. I will take the vote now. Brown,
Yes.
Bradley,
Yes.
Shivers,
Yes.
Desmond, Joel, Mark,
Yes.
Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter,
Yes.
Robbie,
Yes.
and Krieger.
Yes.
Okay, that's unanimous, so it passes.
So I can't tell if that went so fast because we're all exhausted from the first topic, or if the first topic would have gone faster if we led with this one. But nice work, Joel. Thank you everyone for being so focused. All right, Erica, please guide us to the next agenda item that will require a vote.
That would be examining the changes to ABA Model Rule 1.16, and I believe that Deepika was going to kick that one off.
Sure. So I'll try to keep this brief because I know we discussed this at our March meeting as well. But this is in response to the request we received to consider whether to adopt changes to California's rules that are similar to or track the recent changes that were made to the ABA model version of Rule 1.16, which essentially explicitly impose a diligence inquiry into whether or not representing a client would result in client using the lawyer services to commit a crime or fraud. The working group met on this topic in December and kind of presented our recommendations in March, but without the benefit of something written to look at. And the general idea, the proposal, was to not adopt similar recommendations to the California rules for a couple of reasons. The first was that, the report accompanying the amendments to the ABA model rule revisions did acknowledge that this is already implicit in the rules, right? The amendments were really intended to make explicit what was already implicit in the rules. And similarly, we think there's an implicit requirement in the California rules as well to conduct due diligence on a client, ensure that it wouldn't result in a violation of law or the rules of professional conduct. And I think the second concern was really the lack of a limiting principle in the amendments to the model rule and how that might translate to the California rule. And in particular, at what point an attorney can kind of take their client's statement in response to this due diligence as true, and to what extent the attorney needs to continue digging and doing that due diligence if they've received that kind of response from the client. So those are the two reasons we talked about to bolster our recommendation to not adopt similar revisions to the California rules that's set out in this memo. But glad to hear everyone's thoughts on this.
I thought this memo was excellent. And I agreed with it. So my thoughts are very brief.
Yeah, I did. I also was fine with the rationale that was shared to not recommend adopting it or amending.
Ditto.
All right. Does anyone have any concerns they want to, let's just flip the question, right? Any points of contention? So our vote would be to approve to send this to,
Let me, I
Yeah.
come to that.
yeah, because this is weird, right? This is different.
It's a little bit of an interesting one, yes. So what happened was once the ABA adopted the amendments to the model rule, they sent a memo to every, to my knowledge, jurisdiction, I believe every Supreme Court that handles the rules or other entity that handles the rules in case there's another one that I'm unaware of. And that went to Chief Justice Guerrero with the California Supreme Court. Because based on statute, the state bar handles initial considerations of rules of professional conduct in most instances. Justice Guerrero then sent it to the state bar's executive director, who in turn sent it to COPRAC based on how things are handled at the state bar. So if the committee were to vote to adopt the recommendation of the memo to not propose any amendment to California version of 1.16, that memo would then go to the state bar's executive director, who would, and then in turn kind of do the reverse of the process, send it to the Chief Justice.
Great. I move that we approve.
I second.
All right, I will take the vote. Brown,
Yes.
Bradley,
Yes.
Shivers,
Yes.
Desmond, Mark,
Yes.
Mercado, Munoz,
That was Mercado, yes.
Mercado, thank you, Eleanor. O'Reilly,
Yes.
Poindexter,
Yes.
Robbie,
Yes.
and Krieger.
Yes,
That's unanimous, so it passes.
we're on a roll. I don't want to jinx us. Erica, what do you think would be, and this is the jinx, what would be brief so that we can get it done in a half hour and go eat? What do you think would be good?
I can walk the committee through the public comment on either of the items I was going to discuss, but probably flat fees and termination would take longer, but hitting about that 30-minute mark.
Great, I suggest we do that, and I appreciate it very much, Erica.
Great.
Thank you.
Okay,
Erica,
so
which thing did you say, Erica? I'm sorry, I didn't hear
that
you.
is a opinion number 20-0003, which on the agenda is item B4. And so just to set the stage a little bit here, so this went out for a 90-day public comment, and it was returned at the beginning of June. And we received 5 public comments on the amendments to this opinion, 2 in support with no additional comment other than indicating their position in support of the opinion. 2 supported it if modified, and that was the California Lawyers Association and then an anonymous individual. And then 1 who indicated opposition to the opinion, also with no comments indicating their position one way or another. CLA was really the only one that provided substantive comments. The anonymous commenter who supported if modified essentially indicated that parties should be permitted to contract freely and had issues with creating stages or milestones for flat fees, because then it seemed to that person to be no different than having a hourly fee, essentially, if you're going to do it in that regard. So then going to CLA's comments, they were mostly relatively minor changes that we can either talk through, but they're relatively non-controversial. The biggest one that they discussed was that the opinion seems to need a little bit of clarity added to it in certain areas, including clarifying that the section that talks about the need to return an unearned flat fee for an advance fee needs to be addressed in a way that clarifies that the amount of a fixed fee needs to be considered if the services are not completed, regardless of whether or not that fixed fee is paid in advance. So if you're going to bill somebody for a portion of the fixed fee or refund a portion of the fixed fee, you're going to have to do that same kind of calculation one way or another, regardless of whether or not you're holding it in your client trust account or in your operating account based on providing disclosures to the client. So that was kind of one of the larger things. Another area that, other than, again, just kind of minor changes that CLA suggested a fair amount of edits towards were removing a lot of references in this opinion to the prior versions of the rules. So on page, Andrew, if you want to bring it up, just so I can kind of walk through it, if you don't mind. At the end of page 2 of the opinion, going into the beginning of page 3, there is a section that talks about the prior version of the rules, the pre-2018 version. And CLA essentially suggested eliminating that because it kind of creates some confusion. I would agree with that. We're now almost 6 years into this version of the rules. And so adding reference to the prior version, I don't think is necessarily that helpful at this point. And then on...
Sorry, Eric, it's...
No problem. Let me give you a second to get it open and then I can talk through it. Thank you. So looking at page 5, the top of page 5. So this section, sorry, scroll up to page 4 a little bit. Apologies. So this section largely talks about the disclosures that are required of the risks in keeping a flat fee in an operating account as opposed to in a client trust account. And CLA's comment here was that there needs to be a clearer distinction that's indicated between what is required versus either best practices. And so discussing that, the consent is required to keep the funds in an operating account. But this section describes communicating to the client the risks of those funds being kept in the operating account. And there's nothing within the rule that actually requires that. So 1.15B does not make that requirement. And so just kind of fleshing this section out a little bit more to clarify that it's the committee's opinion, if that is the opinion, that part of that consent should include a disclosure to the client that this means that the funds, perhaps may not exist in that operating account when they come seeking a refund of the unearned fee. Again, just kind of scrolling through, there was another reference to distinguishing between the current rules and the former rules that they suggested be deleted. And then if you look at kind of middle of page 5, going on to page 6, there's a discussion about quantum merit in this opinion and tying it to an hourly fee. And CLA's point here was really that, similar to the anonymous commenter, that the whole point of a flat fee is to get out of this hourly fee discussion to some extent. And so they suggested providing better examples or a better analysis under 1.5B factors of how to address what constitutes a reasonable fee if the full services aren't completed. That would, and then also suggesting that the opinion could include commentary that indicates that this could be worked out in the actual fee arrangement in advance, so that it's not something that has to be determined based on quantum merit, but could be predetermined before the fact, which gets us maybe to that conversion clause conversation that we had this morning. So those are kind of the biggest things. And then they did suggest reordering sections B and C of the opinion, which are on pages 5 and 6, just to kind of go through the proper order. So you would, have the flat fee. If the services are not completed, you would look to the fee arrangement and the retention agreement to determine what should be refunded based on milestones or otherwise, and then move past that into a quantum merit analysis. So just reordering sections C and B to make it kind of more procedurally accurate in the opinion. Those are the big changes. And then one other is in section D, which is on page 7. There's a few sentence analysis of an ethics opinion that was never adopted. It's kind of mid-page where Angela is showing in 2008. It's describing a never adopted opinion, and they suggested removing that. I would agree, 1, because the analysis is under the old rule. 2, it's very hard to find this anywhere. So we could certainly link it, but it's an opinion that was never adopted. So it actually has no value. It's not advisory even, because it was something that was never adopted by the Board of Trustees as a co-prac opinion. So that pretty much covers it. I'll just note that the working group for this committee is Sarah Vanola, who is not here today and will be terming off in her advisory role after the September meeting. Brandon, who will become a non-voting member, and Joel, whose term also expires at the end of the 2024 committee year. So staff is very aware of the proposed changes that could be incorporated to this opinion and would be happy to make those changes in advance of a future meeting for the committee's consideration. We would just need a working group to send it to evaluate and have that discussion. And that could be done in advance of those meetings, but just we may want to add someone to that working group so that there's some continuity if this moves past the July or September meetings.
Yes, please. Volunteers, I know it's exciting. Topeka, wonderful. Topeka will have the only vote on the working group, so that'll put her in an incredibly powerful position.
Yeah, it would. And again, I do think that staff can probably have this ready to share with the working group. Because of the tight timeline between this meeting and the next, hopefully the working group could have a meeting before the July meeting that looks at the edits, and then it could ideally be presented at the July meeting again.
Hey, Erica, Elizabeth raised her hand. I just want to make
Oh,
sure.
I'm sorry. Thank you. Sorry.
It wasn't an accident.
I know.
I meant to do that. Yeah, I'm happy to help however I can.
Great. Thank you, Elizabeth.
So it doesn't, at least at superficial reading, look like there's any significant changes to the opinion that would necessarily require it to be issued for another round of public comment. But obviously, as staff and the working group kind of go through the proposed changes and determine whether to include them or not, that's something that will have to be evaluated as well.
Great. Thank you very much, Erica. And thank you to our new volunteers on this item. So Erica, are we risking too much if we try to fit one more in before lunch? Should we break now, or do you think you can do colleague impairment quickly?
Well, yeah, I just said it'd take me 30 minutes to do that, and it took 3.
Awesome.
Talking too fast. Happy to address the colleague impairment opinion, very high level. So this one is one that, frankly, similarly, just to kind of set the stage. So this is an existing opinion. So the colleague impairment opinion was adopted by the committee and the board in 2021, and it addressed essentially what to do if you are aware of a colleague who is unable to engage in the competent practice of law. What this opinion did not include was Rule 8.3, the duty to report another attorney for specific misconduct. In fact, the opinion, because of when it was adopted, said there was no California version of Rule 8.3, which was pretty misleading at this point because there is. So the changes that were prepared by staff and then voted out by this committee for public comment were essentially just to indicate that there is a version of 8.3 in California, and to indicate that a attorney should evaluate whether or not, based on the colleague's impairment and what has happened based on that impairment, if there's also a duty to report that attorney pursuant to Rule 8.3. as the committee had that discussion, the committee, before sending it out for public comment, if you'll recall, decided to keep it pretty high level as it related to 8.3 because it got complicated very quickly and was going to turn into an 8.3 opinion as opposed to a colleague impairment opinion. And that's kind of the feedback that was received from a few of the commenters, was really that just like they don't either, there should be no version of 8.3 at all, or that they don't understand the duty to report under Rule 8.3. So the takeaway from the comments is really that perhaps there needs to be a Rule 8.3 opinion that addresses what needs to be reported and otherwise. The other California Lawyers Association also submitted what I would consider to be the more substantive edits on this, and they're really minor, much more minor than they were for the last opinion we just discussed. But so currently the opinion says the lawyer should evaluate whether they have a duty to report an impaired lawyer. They said that based on Rule 8.3, that needs to be changed to a must, which I would agree with. We said enumerated rules or enumerated conduct in one area, and they suggest getting rid of the word enumerated. There's an id citation, and it's not clear what that id citation is being cited to. And I believe that, oh, and then clarifying what constitutes a significant development, which is not tied to the 8.3 changes, but they were pointing out that the opinion does indicate that another attorney may have to communicate the fact that the colleague is impaired to the clients. And the paraphrasing of the duty to communicate under Rule 1.4, they don't think was an accurate paraphrasing of the obligations under that duty. So they suggested making some minor changes there.
Weren't there also some comments that thought that this was, that they had no idea that the colleague impairment opinion existed previously and they were mad about this whole concept?
Yes, there was an individual who commented that they didn't, there were some, Girardi related comments. There should be no version of 8.3 comments. And then there was one individual who didn't like the use of frazzled in the opinion, which related to the original version of the opinion, 2021-206, because, that's not exactly a clear term as to what constitutes frazzled versus leading to, versus impaired. So certainly the committee could revisit that issue and maybe remove that terminology from this opinion. I'm not sure that the opinion has existed for 3-ish years now without any issues in that regard. But that's something that the committee could consider. Otherwise, I'll just point out that other than the Rule 8.3 changes, the other changes that were issued for public comment was just clarifying what the lawyer assistance program actually can and cannot do, because it was not exactly accurate in the prior version of the opinion.
All right.
So this is another one that could certainly be handled by staff to make these minor changes and sent out to the committee at an upcoming meeting for review. Again, none of these are significant substantive changes that I believe would have to go out for an additional round of public comment. There just is no working group at all for this one. So when staff made edits, I sent them to Brandon in his role as chair, which we could certainly do again because they are such minor edits. But if the committee did want to have a working group to review those in advance, that would be fine as well.
My suggestion is we send it to me and anybody else who speaks up right now.
I'm happy to look at it if helpful, Brandon, but if you don't want the help, no problem.
You can actually you can do it entirely. I'm not
Sure.
Yeah, great. Eleanor is the working group and this is fantastic.
No problem.
Thank you, Eleanor. I appreciate it. Sure. Okay.
I might be able to do the succession planning comments in like 5 minutes.
Amazing. This is really exciting. Okay.
Want to roll the dice?
Let's see what we get done here.
Okay, we got comments back from the succession planning opinion that has been out for a while. This is the second round. We previously went through a round of public comments and made some revisions. You might recall that in the most recent revision, we ended on a balanced approach that suggested that an attorney has an obligation to assess whether they need to develop and implement a succession plan. And as you might also be able to anticipate, the comments were on two ends of the polls related to the balancing. They either felt that it was too onerous and it wasn't possible for many attorneys to do that, even that amount of planning, or on the other end, which tended to come from the bar associations, including PREC and CLA and Orange County, that it didn't go far enough because I think at least CLA primarily prefers a bright line rule that says that you must have a succession plan in place to do X, Y, Z. There were some other comments, but I felt that if we, as I do, believe in the balance that we struck, then most of the substantive comments wouldn't be applicable. And for that reason, I could highlight just a couple of them that I feel like the staff could implement, and then we could have another version that we could actually maybe finalize. And again, it's the question of whether you go back and try to come up with the bright line rule, but this has all been litigated here in great detail. And I feel comfortable with where we ended up. I don't think it's too onerous, and I don't think it's too vague. I do think it's probably the leading edge of a movement that's going to require a lot more work. And, one of the comments was, well, what would a succession plan even look like? It does seem like that's something that in the future we might want to address with specifics, because people seem to be under the impression that it's really difficult to do and onerous.
Right.
And I don't think it really has to be. So that's something for the future. But in terms of this opinion, I think that I would make and highlight a few changes that I think if Erica's comfortable with, that staff could go through and do a new round, send it to the working group. That includes me, and I don't even know who else.
I think I am. So,
And
but
I am too,
but,
because I've
yeah,
put myself on
so-
too many working groups and then I'm of limited value on any of them, and that's all my own doing.
It's the three of you
Yeah.
who just spoke of. It's
Okay.
Dan, Brandon, and Cassidy.
Okay,
Yeah.
I didn't see anything in there that struck me, and Corey, this is the second round of public comments. There was still a lot of public comments because people don't like the balancing. They want one or the other, which is not surprising. I didn't see a lot in the public comments that suggested any errors or other things. There might be a few minor tweaks in tone and comments, but that's about it. I think it's suitable to send to staff to make some changes and then have a new revised version that we can finalize.
All right.
Yeah, I I would agree with that. I mean, the only kind of interesting comment that I would reject and including was CLA's suggestion to include a reference to 1.7B on that there's a duty to communicate, there is a duty to communicate that if you're having health issues or medical issues or need to take time off. But, go so far as to present it as in a conflict scenario. And I thought that just that's too fraught.
I didn't find that compelling, but just for the committee generally, the conflict would be that you now have a desire to hide the circumstance that might interfere with your ability to do something for the client, and the client has obviously an interest in knowing everything about you. It didn't seem applicable. In the broader context of the opinion, I think that context is already present.
Right. Yeah. I mean, I didn't think that it's necessary to get informed consent to
What are you going to get
do the
informed consent for? Can I get informed consent to conceal my health records?
Right. Well, it would be informed consent to like continue the representation.
In light of
and
what?
it's- Right, like it's more
Understand.
just a duty to communicate to the extent there's a significant, it constitutes a significant development, but I don't think it's a conflict scenario.
Yeah, I didn't think, I mean, it's possible that after the fact, something like that could be asserted against the attorney, but I don't think it's something that seemed to merit attention here, and I didn't think it was workable to get informed consent.
Yeah.
You're concealing it.
Right.
I also
What
thought,
else?
I mean, if we start going down the road of saying like you need to tell your clients if you have a heart murmur, or whatever, I mean, that's not going to work.
But yeah, I agree with all your comments. I went through the public comments as well. I mean, my general thought was, when everybody's saying, well, what, when they were saying like, what is a succession plan? You're not telling us exactly what it needs to be. And I thought, well, no, this is more about, you need to take reasonable steps to assess whether or not, what's appropriate for your situation. And that's kind of similar to 5.1, you need to have reasonable public policies and procedures in place for making sure the subordinates comply with the ethical rules, and it's sort of along those same, that it's analogous to that standard. So I agree with your suggestion,
It
recommendation.
might be that, and I say like that the public would benefit from knowing what one of these might look like beyond just the baseline stuff that's already out there. But it depends on what your practice is. And a few people in the comments made a comment that I have different kinds of cases that would have different types of destinations if I were not available. And you're like, well, that's the plan, right? That's the plan. So,
yeah. I mean, the standard is you got to think about it. You got to
but also that's what we have said is you have an obligation at a minimum to assess.
Right. Yeah.
That seems
And
fair.
that's, yeah. I mean, and it's the practical reality is that that's not happening in many, I mean, it is happening, but it's not happening enough nowadays, especially with, everybody growing older, the boomers and all that.
I think there is a tsunami of this coming, just based on demographics.
Yeah, I wonder if there's gonna be a similar proposal for the judiciary.
Great question.
So
Yeah.
it would be helpful to know which items in the public comment you thought were worthy of inclusion.
Yeah.
Offline and do that if you'd like, but I think for the benefit of the committee, that might be helpful too.
Yeah, I can point to one. There were a couple of comments that said deleting from, I think, the digest, the phrase that said, based on firm size and nature of the practice. And I know that was from a previous version of the draft, but I thought that was an appropriate comment because it's not just those things. And if we start listing those things to the exclusion of others, it doesn't really make sense, because what we're really saying is you have to go to your practice and assess using the factors that are applicable to it, in some fashion that makes sense, what would happen to protect your clients if you were not available. So there's a minor change that I felt like that could come out and it wouldn't change any substance, and it's vestigial. I think it just didn't get pulled out when we changed the recommendation to be assessing.
Would you, is that comment, I'm sorry.
Go ahead.
Is that comment? I think I'm trying to find it right now, but there's also a reference that says it's like particularly important for solo or small firms. Do you think that's inconsistent with the change that you're proposing now, or would you leave that in? I mean, I think it's relevant. I would leave it in, but I'm wondering if, it's also suggesting a limitation you don't want to suggest.
I did think about that because I personally think that it's appropriate to highlight that. If you have a firm with other people in it, they should also have the duty. But if you don't have a succession plan and you're the only one in the practice, it's obvious how much different that is going to be.
Greater impact, yeah.
Right. It was also, by the way, the public comments that came on the poll objecting to it tended to come from solos who said this is one more thing that.
Oh, that's interesting.
Yeah.
And I can send you my notes also, Erica. There's just a couple other ones. There was a comment, I think, from CLA that referenced the discussion in section 1 that we could tighten up the language around what is required versus what is recommended, in terms of the types of things that people do, because some of that, and I think from a prior draft of the opinion, it just was slightly more directive, and then we changed the tone to being duty to assess. But we can go back again and try to make it more precise. Those are the only sort of changes that I recommend.
Great. So there's nothing to vote on here. This is just an action plan. And then we will have a revised version at a future meeting to approve if we approve, correct?
Yes.
Great. Well, Dan, I appreciate this very much. And Erica, as always, I appreciate the staff helping out on these revisions as well. All right, is there anything else on this item, or should we break for lunch and come back at 1:30?
There's nothing else on this item. There are, I believe, only 2 items left to discuss.
Should
Today.
we barrel forward and then end early? Yeah, I'm seeing that lit up the little boxes on my screen. That was very attractive.
I'm sorry, there are 3 items to discuss, so it may be too much. But so what those are, just for everyone's knowledge, is a brief discussion of next steps on item B1 19-0004, which is the client file release and retention duties that was discussed at the May meeting. And then the consideration regarding the proposed amendments to rules 3.6 and 4.1. And then consideration of new opinion and advisory topics.
Mine will be very quick about the file retention. And if the only opinion requests are the ones we've talked about, Erica, they have a possibility of being very quick.
Yeah.
So do we want to risk this and push on? If anyone gets too hungry, we can always just stop and eat, okay?
Let's roll the dice.
All right, I'll start with, because this is why this one's really quick, is the client file. The marching orders from our last meeting were that those of us on the working group were going to try to find somebody who practices criminal law and talk to them about this and get their feedback. So I found one person and talked through this with him. He is a solo criminal defense attorney. Talking through the issue, he loved our opinion. And then he made the mistake of inviting me to send him the opinion and all the public comments, and he hasn't gotten back to me. So I fulfilled my marching orders, and it was a slightly, if shallow, but positive result towards our opinion. There was one public comment. I went back to the comments we got in 2022, and I can talk about this with you, Erica, offline, but the Ventura County Senior Deputy Public Defender mentions a statute in the government code that he believes we are ignoring and sort of contradicting a bit regarding the ability of public defenders to be able to destroy non-felony files. And I just think we need to look into that because I don't know anything about it. So that was my investigation. Did anyone else make any progress reaching out?
Yeah. So Brandon, I sent mine to you on June 6th. Did you not get that?
Oh my goodness. If I didn't, I mean, I missed it and I apologize.
No, that's okay.
Are you able to just sort of summarize it?
Sure. So let me put it over here. So I reached out to a couple, and the first criminal defense attorney, he indicated that there should be a distinction between misdemeanors and felonies for clients' criminal file retention. I'm just going to read what he said. The rationale is that once the client's liberty is at risk, i.e. he or she was or is arrested, then those documents should be needed later for a number of reasons, such as to prove whether they were not convicted. There should be at least a 10-year minimum on physical files and no time on electronic. We never know when a person is going to need such information for a job or to get those records sealed. 2, a potential basis for a misdemeanor/felony or liberty at risk distinction for retention of files would create a more confusion and increase files for attorney, thus creating an additional standard where there already appears to be differences on retention of documents.
See, this is really interesting. These are 2 practitioners because a lot of the public comments we received were from solos saying, this is a crushing burden. This is another outrageous thing that the bar is doing. But Vikita and I have just reached out to people who said, yeah, this is a lot of work, but this is really important. It's worth doing. So I found that pretty interesting.
And they don't support a distinction between misdemeanor and felony or even at liberty, right?
Right. They think that's a hard distinction to make, and you never know for what purpose things would be used. And then the attorney I spoke with made the point that going forward, everything or almost everything is electronic, and it's just not the same burden forever, you know?
Yeah, something that came to mind that happened this week was the Maryland governor who commuted this sort of sentences of many thousands of marijuana convictions. Who knows when those might have happened? And if you want it commuted, you probably have to submit something, right? It'd be nice to have those records at that point.
Right.
Just as an example.
Did anyone else have an opportunity to reach out? I think Eleanor and Deepika are on the committee, but I don't know if you guys had a chance.
I have not, but I will. I'll do that
Okay.
today. Actually, I fell off my radar, so apologies to the
No
group.
apology necessary. It barely
Same
stayed
here,
on
and I can
mine.
do it before our next meeting.
Great. And then hopefully I can try to research a little bit about this government code and see if it's an issue or a non-issue in terms of our draft. This is the oldest opinion that, like, nobody who worked on this opinion is still on the committee, right? Interesting. Well, we should be proud of ourselves for keeping it alive. Okay. So I think that's all we have on
How many files have been destroyed while we've been considering this?
thousands of important files, right? Well, the funny thing is there's a prior COPRAC opinion that addresses a lot of these things. And a lot of our public comment obviously didn't know that. I didn't know that.
It's not that old either.
Right. And they're like outraged at this new thing. I'm like, no, this is really just working off of an existing standard. But so anyhow.
I do know that Mary, I think it's Mary Grace that said she was going to be reaching out as well
Yeah.
to the Defense League.
Right. But I don't know when she's signing back in.
Yeah.
All right. Well, we can circle back to this at the next meeting too. So I think that's all we have on that item. So should we turn to what's the next fastest thing?
There's two left, rule 3.6 and 4.1. It's probably be the next if Cassidy is.
Cassidy, is this worth trying to talk about now, or is this something we should actually break? And I mean, how substantive do you think it'll be?
It's substantive, but I think we're just kind of preliminary. It's
Okay.
preliminary thoughts. And that there's still some work to be done by me and the rest of the working group. So basically, so we can cover it now if you guys don't mind. Is that what we're gonna? Yeah. Okay. So the issue, I don't know if you want to put up the memo, Angela. But the issue is a request by the California Judges Association to amend Rule 3.6 and 4.1 to include the language and the red line language. Basically has to do with public criticisms by attorneys against judges, which leads to threats against their safety and death threats and that sort of thing. And usually it's done through the media or social media. And so there was a proposal to amend these two rules. One has to do with misrepresentations of law and fact. That's the rule 4.1. And then 3.6 is a lawyer who is participating will be participating in litigation. Sorry, I think that's the ellipses. By means of public, is it I'm sorry, I don't think we have the full, there's a substantial likelihood. No, go ahead. Anyway, it's basically to include language that prohibits public comment that would have a substantial likelihood of placing the safety of any judicial officer or other person associated with I think the matter, if you scroll down a little bit more, the proceeding or the judicial officers or other person's immediate family in jeopardy. And then Rule 4.1 was to add this subpart C, prohibits making a false or misleading statement of a material fact to the media or social media. So we met with the working group, and it's Deepika and Vikita, I think, yes, and Brandon, but and so
But I couldn't make it.
you can make it. That's okay. We have a very quick meeting. But but we talked about the proposals in that one, I think because it is kind of such an urgent issue and such a present issue right now, that amending the rules, which takes a lot of time, really won't address that urgency. Coupled with the fact that we do think that existing rules do cover the scenarios that they are, that they're intending to address here. So we looked at 8.4C, which is engaging in dishonesty, fraud, or deceit. I really think 8.4D is really the one that does cover this type of conduct, professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. I mean, threats to a judge or public comments that may lead to the risk of harm to a judge would certainly be prejudicial to the administration of justice. And then Rule 4.1 in and of itself, I think, may cover it because it's false statements of material fact or law to a third person. The question is does third person encompass statements to the media or social media? I think that's debatable, but in any event, I think our proposed approach is to draft an alert or an ethics opinion to get out as soon as reasonably possible on this kind of narrow issue, but urgent and important issue. And it could be pretty straightforward and brief, just to say, look, these types of comments that lead to threats are covered by the existing rules, and here's the analysis, and get that out there. But some, there's still a little bit of homework. I haven't had a chance to research if there are any ethics opinions out there or other authorities that discusses this issue. We also, Erica, I think we wanted to see if the requesters, if the CJA has looked at whether or not the existing rules apply and what their thoughts were on that, and kind of see if they've because it's kind of an obvious thing. The first step is to look at that. So I just want to know what their position is on that. So that's kind of where we left it. So if anybody has any thoughts, comments, ideas, we're open.
I like that approach. I just started jumping in here.
Okay. And we will, the working group will take the laboring oar on drafting something. I personally think, I thought this would be the perfect start of the, drafting the first alert. I don't think we've really implemented that yet. So this might be the best vehicle for doing that. So we just
Raquel has her hand up. I don't know if you saw that.
Oh, sorry, Raquel. Go ahead.
I was also thinking an alert, just because you mentioned the timeliness of it. So I think an alert doesn't require to go out and get input and massage it. Is just, it's a communique. So that, so that would be my thought. Thank you.
Yeah, I agree with that. Yeah, I mean, as we know, ethics opinions take a long time. So
how do the alerts get communicated?
Yeah, we talked about this last time. Like we would just be
so a few ways.
Sorry,
Cassie, I apologize.
No, it's okay. I'm just
They could be, it would be posted. So in the same way that the practical guidance was disseminated. So, and that was kind of the first of its kind in a way. So the practical guidance regarding responsible use of generative AI exists on the opinions page currently. So it's not one of the many opinions, but it's on that same page, and that's where attorneys can look to it. When it was adopted, it was distributed via the State Bar's communication channel. So it was distributed via social media. It was picked up obviously by some legal media. And then additionally, it was distributed through the all licensee newsletter that goes out on a periodic basis, typically about quarterly or so. So it went out to every licensee in California. So something like that could be the similar approach for this, where it would go out, via social media and likely through whatever the next all licensee newsletter after it is approved by this committee. And it would not, as you've mentioned, have to go through any public comment process or anything like that.
So a standard for an alert, we can take that leap, which is analyzing existing rules to say that it covers this particular, yeah, I mean, there's no reason that it has to be an ethics opinion,
Right. I think what would be interesting here is, so every COPRAC opinion has that disclaimer language at the bottom, right? Which is, it's advisory only, non-binding, it's been approved by the Board of Trustees. I think we would just be crafting a revised disclaimer of that kind and just indicating, this is an ethics alert issued by the Committee on Professional Responsibility and Conduct. It's not the same as a formal opinion, which goes through like that vetting process, essentially issued for public comment, approved by the Board of Trustees, just to kind of differentiate the two, because this would be the first of these in quite some time, at least for the committee.
Okay. Yeah, I mean, I think that's a good plan. It's just now, okay, are we gonna get it written by the next meeting? Or do we want to go back to CJA and ask their input first? Because realistically, we probably, I mean, I don't know. Can we get it done by the next? Can I actually? Because I need to do the in-house opinion for the next meeting, and I really want to get to that. And I don't know if I can draft this and that. So can I get a volunteer from the working group, which is Deepika and Vikita and Brandon, to actually draft this alert, and then I can, provide my revisions and input as well. Is that, yeah? Deepika?
I'm happy to. I can take the.
Are you sure? I think you volunteered for something else too, but so just as long as, okay. Okay,
help
so
you.
good.
These
Deepika
are
too.
much shorter than the ethics opinions we issue, so no problem.
Yeah, great. So, and I think, I think it could be, 2 to 3 pages maybe max, so I think we should be, or 2 pages. I think it should be pretty straightforward. Okay, well, with that, then I think we can, target getting an alert drafted by the next meeting for review. And then the other thing I was going to do, and I sort of did, was run it by the Association for Disciplinary Defense Counsel Board. And we had a board meeting last week that I was going to do that. I did circulate it, but I couldn't attend the meeting because it was my daughter's 8th grade graduation that I completely forgot about. So I had that conflict. So I wasn't able to discuss it. So I can go back to them and see if they had a chance to review the issue, and just see from a disciplinary standpoint, whether or not, how would a lawyer who posts something on Twitter or X about something that leads to threats, how would that lawyer be disciplined? Or how would that be, how would that be reviewed from a disciplinary perspective? And that's kind of some input that I wanted to gauge. So I can do that too.
Great. Well, thank you, Cassidy, and thank you, Deepika, for volunteering on yet another group. I think it's wonderful.
Thank you.
All right, Erica, what's our last item? It's the new opinions, the ones we've talked about. Okay, great.
Yes. So Angela, if you could bring that item up and we can kind of talk through it, and I'll just kind of get started on this. So since we have been typically discussing new opinion requests about every 6 months right now, So we did that at our meeting in December, and it's been 6 months, so here we are. And since then, we have received actually a fair amount of opinion requests that we have gone through. Brandon has gone through the committee's leadership. So Cassidy, Brandon, and Sarah have seen these. They've been forwarded to them. And then behind the scenes, staff has done a little bit of workups on some of them. Some of which is posted with this agenda item, and some of which is kind of behind the scenes because it required doing some legal analysis, frankly. So we can kind of talk through these here. And then just as an FYI, after this table that you're seeing that Angela is showing, we have created an opinion log that we also put as part of this agenda item that we will post on the committee's SharePoint site as well. That just gives kind of a status of the universe of all of the opinions that COPRAC has, including the current working groups for each of those opinions. So as you can see, it's really small on your screens, but it says the opinion's interim number, the topic, who's on the working group, when it was last discussed, and then comments. We did include some older ones just that are essentially done at this point. That's those first 3. So you could just kind of see whatever happened to those. We did a lot of digging through old agenda items and watching old meeting recordings to kind of figure out where things had been. So those that say on the, going back to the other table that is the opinions request document, there are 2 categories. There are those that are at present, and then there are those that are the decline to opine. The ones that say the disposition as hold, just so you're aware, does not mean nothing is happening on those. That actually means that they are currently with the committee for consideration, but not necessarily moved forward to an opinion. So that is the abortion access topic, which is number 2 that Brandon and others are looking at. Model Rule 1.6, which now will come off, obviously, and a few others as well. So what is new for this meeting is items 11, 12, 13, 14, and 15. And I can just really high level talk through those to the extent it's helpful. So number 11 was a request related to changes to the Corporate Transparency Act. And we received a request regarding an attorney's obligations, which is addressed in a memo within this. But basically what they were looking at is that with in 2021, the Corporate Transparency Act was adopted by Congress, which creates a reporting requirement for businesses that went into effect on January 1st of this year. And there are certain, there's a pending federal lawsuit in regards to this with a current injunction for those who sued. So you know, this is kind of related to pending litigation to some extent, so we may not want to address this for that reason alone. But assuming that the requirements under the Corporate Transparency Act do move forward even, that's kind of what the analysis is in the memo that looked at this issue. And what it requires is that a company applicant who has to submit certain reporting requirements can have a lawyer do it for them. And there's ongoing reporting requirements that exist and penalties if the information regarding a corporation is not accurate. And there were concerns by the lawyer who made this request regarding their liability, essentially, if that information is not updated and maintained. Frankly, staff's perspective is that this relates to, you know, kind of a limited scope engagement of some kind, indicating that you're going to fill out the initial paperwork for that client, and that, you know, giving them essentially a warning that if this information changes, lawyer representation has ended, and they need to make sure that this information is current within the time frame as required by the Corporate Transparency Act. So that's staff's interpretation of the request. I can certainly answer some questions on it, but based on that, I don't know that this is worthy of an opinion on this particular pretty narrow topic.
Would it be appropriate for an alert?
It could be, certainly, yeah. So it certainly could be. How this typically works is if a committee doesn't want to take this up at all, a decline to opine letter is issued to the requester, and that's it. But if the committee does want to prepare this as an alert, that would certainly be helpful. FinCEN has an FAQ where they're answering some of these questions. This is not, as of yet, one that has been answered. And so perhaps it's something that is better directed to FinCEN to answer versus the this committee, because it's going to apply to lawyers in every jurisdiction, not just California. But it is certainly something that could be the topic of an ethics alert, because it's a pretty succinct topic.
Yeah,
The other issue is, aren't there some state CTAs being issued? I don't know if California is doing one. I think it might be, but I think there's going to be more development in this area.
Yeah, I just saw something on that. Just recently that Newsom signed something, I think. And we've also, my firm did an alert on this. I don't know how extensive it was. I can look at it and see. I've seen a lot of alerts on it from various different organizations.
yeah, I think
But
to me, we do this for firms. We already started filing this, because if you're organized now, you have like a 90-day window to file this. It's not a complicated thing, but I think the question for lawyers, which I don't think FinCEN would answer, is what if the information your clients provide is false, right?
It goes back to the model rule 1.16 analysis to some extent.
Right.
It's a little bit related, and doing your due diligence on your client and so forth as well.
Yeah,
Right, but I can't figure out
FinCEN
if their passport is fake, for example, or whatever, right? I think it could be a good alert, in the sense that you just would be able to point to the rules like that say limited, and what you already described, a limited scope engagement, so it doesn't go on forever. And you might want to get some acknowledgement that they're providing you accurate information, and if they're not, what can you do? Yeah, that's probably, to me, that's the ethical issue. The corporate issue and the other stuff about who has to do it, it's in the guidance, but the issue is the people who are going to violate this and have money laundering operations are going to lie to lawyers if they file this at all, right?
Yeah, that's interesting. I mean, I wouldn't mind considering it. My inclination is that those issues are covered by other rules, and FinCEN makes clear that the company is certifying, not the person who files on their behalf. Even an employee, whether it's the lawyer or the employee, the company is the one that's on the hook.
Yeah, I don't think it's, if it were anything, it might be an alert, but not beyond that, I wouldn't think.
That makes sense to me.
Is there anyone on the committee who's interested in drafting the alert?
Once again, by my own comments, I have volunteered myself. I'll do it. Common decency requires.
Great. Okay. The next one, item 12, was a request for an opinion on whether a law firm technology service company can pay commissions, bonuses, or referral fees for sales of their service to law firms. Essentially, a sharing fees with non-lawyer question is really at the heart of this. It's something that I believe is directly addressed by the rules, and we could certainly indicate that as much. The larger concern is this particular opinion request was about a very particular legal technology product. Obviously, if this was something that the committee wanted to consider, it would have to be generalized. But that was essentially the heart of the request, is whether or not they can receive percentage referral fees, and which is not permitted based on the rules as well.
And this one was really close to, like, it was so specific, it was kind of just asking for legal advice on a particular business model. Yeah.
Yes.
So probably not appropriate. Certainly not in the form that it was submitted.
Yeah. And what is interesting, I'll just add, is that they did get an opinion from Utah, and obviously Utah has a different version of the rules regarding sharing fees with non-lawyers, and Utah said it was just fine. So I think that was kind of one of the bases for it, but obviously California's versions of those rules is very different right now. Okay, I'm gonna
Before you go, Eric, I have a question.
Sure.
So if we say we're refusing to opine, but you know that there's a California rules that would,
Yeah,
do you include that in the letter?
we do. Yeah, we
Okay.
typically provide the irrelevant authorities for them to consider. And then
Okay.
tell them they can contact the ethics hotline if they have questions they'd like to talk through with somebody.
Okay, thank you.
I'm gonna skip 13 because I think that's the one that's gonna require the most discussion. So going to 14, we have a law school who contacted us, COPRAC, requesting, it's a file retention question. So they have a law school clinic where they provide representation to clients as part of that clinic, and their question related to file retention obligations. So that opinion request was already shared with the 19-0004 working group. And to the extent there's any different analysis for a law school clinic, which I don't think there would be, it can certainly be incorporated into that opinion. So that's one that we would address by saying this is currently being considered by a committee, and there's likely an opinion forthcoming, as well as providing the existing opinion on civil cases or civil files, excuse me. Okay, I'm going to keep going unless anyone has questions. Okay, and then number 15 is a request to opine on whether or not certain activities constitute the unauthorized practice of law. As the committee is aware by board resolution, the committee currently cannot advise on whether or not something does constitute the unauthorized practice of law. This is something that during the COPRAC sub-entity review process is something that we've all kind of discussed, maybe revisited to decide if that's a board resolution that should be sought to be changed so that COPRAC can, especially as it relates to this committee's involvement with exploring, you know, lawyer use of generative AI and other types of things. But for now, based on that board resolution, COPRAC does not have authority to address that issue.
I'd be really in favor of revisiting that. I mean, there's not a lot helpful to litigators who are trying to, this issue has come up, as Brandon knows, having served as an expert witness in a case of mine in the transactional, you know, context where, I mean, there's so many facts that are really clear, but without guidance out there, there's very little published case law on point, and there's really no way to kind of remedy this issue. It's really, I think, vitally important to the public. So whatever we can do to try to get it back on the radar or back on the discussion track, I'm 100% in favor of and would be willing to work hard on it because it's really important.
Thank
I
you.
agree.
Yeah. Okay, so then the last one to discuss is opinion request number 13, which was may an attorney employed by a government agency disclose documents in the attorney's possession that are subject, that are, you know, confidential client information as well as privileged information in regards to an audit, a county audit. So in this instance, the auditor's office and the attorney's office and the agency that the attorney is the client, that the attorney represents, excuse me, are all within the same city governance structure. And so the question was really several subparts. The first part of it being, you know, what are the confidentiality obligations related to this information? And basically, you know, can they disclose confidential auditor in such situation? That's really the ethics question that exists in the opinion request. Sorry, I'm audio feedback. Try again. Cassie, do you mind? Can you mute? Is that better? I think that's better. Sorry. Okay. Apologies. And so what they were asking was, you know, one, can they disclose information to an auditor that is attorney-client privilege and confidential? Two, would that disclosure violate 1.6 and 6068E? 3, would disclosure constitute a waiver of confidentiality or attorney-client privilege? That is a legal question, for which there's frankly some case law that exists. And then the 4th question was, would the attorney be subject to discipline for violating potentially the duty of confidentiality under this? I think this is a really interesting question because it's one for which concerns a city, and especially is asking for interpretation of whether documents that are provided to an auditor would then lose privilege and be subject to a Public Records Act request. My personal thought is that it's better suited for an Attorney General opinion in California, where they can give that kind of advice. That's what the AG's office does for cities and other local agencies. But I just wanted to present this to the committee in case anyone feels strongly that some or part of this should be addressed by this committee. And this can also be tabled to, I don't know if anyone had an opportunity to review the actual opinion request. Brandon, you're on mute.
When we spoke, I was convinced that this was much better suited to the AG's office than us. It was very specific to the kind of stuff that they advise other government agencies on.
So, and just to Raquel, I know Raquel has signed off, but her point earlier, there are certainly some authorities that have addressed this that exist, that we could provide them, that we did as staff did as kind of background research on this topic that we could provide them with, when we indicate that they should contact the AG's office, to the extent that would be helpful for the requester.
I'd be in favor of that approach. My instinct is the same as Brandon's.
Does anyone feel otherwise? All right.
And that is all of the recent requests to cover. There was one that came in, just so the committee is aware, that came in late last week. So that is one that we will be likely sharing, depending on how much staff needs to look into the issue in advance, either at the July or the September meeting as well, to kind of go out of order, just because it came in so recent to when we typically consider these. We don't want them to have to wait for 6 months.
Okay, great. Is there anything else that we should be touching on today? I want to thank everybody for this incredibly efficient second half we've had here. And I hope everyone can enjoy a little extra time in their Friday. So I am going to adjourn the meeting, and I thank you all very, very much.
Thank you.
Bye.
Thank you.